Your Honor, may I make argument, Judge?
Sure.
Thank you, Judge. The sole reason for the stop in this case was failure to maintain a single lane. Most recent case law on this is Hardin v. State, and in that case, it overturned even Lemming, and they went as far to say is that failure to maintain a single lane is not probable cause for a stop.
Hey there, welcome to the Courtroom Files. So today's video covers a little bit of case law in Judge Fleischer's court. So we have a defendant who's there on a DWI and he was pulled over for basically failure to maintain lane. But the defense attorney brings in some case law in this matter and they argue it back and forth over the course of 3 different sessions during the day's docket. And we bring you all 3 of those sessions. But this is interesting because case law and actual law are a little bit different. So a judge is not bound by case law unless it comes from a higher court within the same jurisdiction. So, for example, in Judge Fleischer's case, if the Texas Supreme Court rules something, all courts below that would be bound by it. But if it's a lower court or a court on the same level, if it's from a different jurisdiction, then they're not bound, but they can use it for guidance. So it's important to understand that distinction as they go through this process of deciding whether or not this case law applies when it comes to probable cause. So take a look at it. It's quite interesting. Let us know what you think in the comments about the judge's final ruling and if you think he did the right thing at the moment or if he ruled wrong. Please do consider subscribing to the channel if you have not already. We'd love to have you as part of our very fast-growing community. Put a thumbs up on the video if you enjoy it, and let's roll the game film.
Are you ready? Let's roll, nerds. Come on. Mr. Simon, how are you? Great to see you. You ready? Who do you have?
I am here on Albert Anderson, Your Honor.
Page 1, Anderson, come on up.
Mr. Simon, great to see you.
Good to see you, man. Doing good?
Yeah, you know, working. Good morning, Mr. Anderson. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On December 8th, 2024, the officer conducted a traffic stop on the defendant's motor vehicle after observing it failed to maintain a single lane while traveling west on Jester Boulevard. The officer observed the defendant constantly veering out of the lane and going into the second lane. The officer observed the defendant to be the driver and sole occupant of the vehicle, and while speaking to the defendant, the officer observed a strong odor of an alcoholic beverage and bloodshot eyes. The defendant was struggling while exiting the car and was swaying back and forth while speaking to the officer. Standard field sobriety tests were performed, HGN 4 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The DIC was read, but the defendant refused and a blood search warrant was drawn and executed.
Your Honor, may I make argument, Judge?
Sure.
Thank you, Judge. The sole reason for the stop in this case was failure to maintain a single lane. Most recent case law on this is Hardin v. State, and in that case, it overturned even Lemming, and they went as far to say is that failure to maintain a single lane is not probable cause for a stop.
Well, I get it, right? You have to dictate more than just saying failure to maintain.
Yeah,
You have to have provide
a danger to another vehicle. There's other vehicles around. This is on TC Jester Boulevard, a very sparse road at night. And
So what were the indicative facts?
I'm opening the office.
Yes, Your Honor, we're looking at the offense report.
I mean, obviously, we don't have any body cam, dash cam, so I'm not,
Well, right, but this is just a mere probable cause. I need enough of a statement from the officer in the DIMS saying how he justified pulling the car over in light of failure to maintain a single lane. The weaving statute. I mean, do you need a bit of time? If you want to reconvene in like maybe 30
Yes,
minutes,
Judge.
it's fine.
My offense report's not running for some reason, so.
If we may have a little bit more time.
Mr. Saman, do you mind? Do you have somewhere else to go?
I have Fort Bend to go to. Can I go to Fort
Well,
Bend?
That's going to take hours. If you want to, yes, because you can always zoom in. I have Zoom for you.
I'll wait.
So perhaps maybe, 15 minutes, give them time to look at the OR.
No problem.
Just take a seat for me, Mr. Anderson. We'll come back. Are you ready with Mr. Saman?
Yes, sir.
Are you ready?
Yeah, I'm ready.
Okay, come on.
Should I bring him back up?
No,
All right.
I don't think it's necessary. Can you read it to me again?
PC.
Yeah.
On 12/8/24, officers conducted a traffic stop on the defendant's motor vehicle after observing it failed to maintain a single lane while traveling westbound on TC Jester Boulevard. Officers observed the defendant constantly veering out of lane 1 and going into lane 2. Officers observed the defendant to be the driver and the sole occupant of the motor vehicle. While speaking with the defendant, officers observed strong odor of alcoholic beverage and bloodshot glassy eyes. Defendant was struggling while exiting the car.
That's it. I mean, the crux of the argument is the stop, right? So
Judge.
I guess in this instance, he says that he's veering from one lane to the other constantly.
Yes, Judge. And I understand the issue with Harding, but it's distinguishable. From Harding.
I need to read it first, but
Okay.
what does constantly mean?
I would imagine back and forth.
Okay, just one time I guess it's at
I mean,
least
we
two
don't have that
times, right?
information,
Well,
but
even in Rodriguez, which was the original case that kind of made the stops not probable cause. In Rodriguez, the person that Rodriguez actually veered out of his lane into the shoulder six or seven times. And they found that not to be probable cause because there was no other vehicles around. And in this case, there's no other vehicles around. I think that's the biggest factor that we look at or courts look at.
I don't think that that's necessarily it though, because you could be a danger to yourself,
and
right?
I don't think that
So,
that's
I mean,
dispositive.
the fact that is there other car, I don't think that's dispositive.
Okay, fair enough.
But
Fair enough.
my concern is, he says constantly.
Yeah.
Yes,
What does
Judge.
that mean?
Judge, it's unclear based on the OR. We tried it, I believe we attempted to call the officer right now to make the night shift officer and is off right now. We were not able to speak to him, but I do believe that there is sufficient probable cause. In Hardin, Morgan and I looked at the case. In that case, the right rear tire of the U-Haul truck that the defendant was driving touched and drove on the striped line marking the right side of her center lane. It doesn't even say that she crossed over, she was driving on the line. These are completely different facts. In this one, the defendant here was constantly veering in and out from lane 1 to lane 2. You know, she was a danger to her, he was a danger to himself, he was a danger to the officer that was driving behind him. I don't know if there were any other cars around, Judge. I do believe that there is sufficient probable cause to just.
Okay,
at
so
least-
I guess, Mr. Saman, I need to read what it is, the case, at least. You know, if you want me to, I'm happy to. But I need a little bit more time.
Yeah, there's also Rodriguez v. United States. That's one to look at in which.
I mean, I need to look at both of those, read them, and then I need them to see it.
Also cited Win Hardin, and I think that one would be valuable for you to look at as well,
Okay.
Judge.
So I guess, do you want to go and then you want to zoom on?
Whatever you want me to do, Judge.
Yeah, I want to go through the arraignments that way because it's going to be a little more time.
I don't mind coming back.
Okay, yeah.
You can.
But
Might lose.
for what it's worth, remember, like, we can't try a case now, but this is just a mere probable cause.
I fully appreciate
know,
that.
so-
I just don't think that our probable cause is articulated in this case.
All right, go. You know what? Do me a favor. Leave me your cell phone just in case. Will you? And then I'm live streaming, so don't say anything out loud. But leave it to me.
Yeah, sure.
When we're done, I'll reach out to you. I'll text you, and then wherever you are, either we can zoom in, or we can, if you're still here, then we can do it here.
Thank you.
Okay? Do you have copies of the case so I can at least see it or a site? Sure, do it.
Thank you, Judge.
Appreciate it.
Whenever I.
Happy to do it.
4 minutes, I'll do that.
Yeah. Okay.
And I'll also email you both our cases as well.
Thank you.
Okay. For sure.
And we can leave, you can leave?
No. Because if I find probable cause, I have to do bond conditions.
Oh, okay.
You know, you can, he
Okay.
can't.
Okay.
Yes.
So, Mr. Saman,
Yes, Your Honor.
the cases that you provide me, like, I think the distinguishing thing is that all of them have like one instance
Well,
of
not the Hernandez, which is kind of the genesis of all these, and that one.
Hernandez is one time.
No, Hernandez is 4 to 5 times, I think, is what they stated.
I'll point out that Hernandez was rejected by the court in Leming as well.
Yeah, but then Lemming was rejected by.
Lemming was not
Hardin.
rejected by Hardin. They
You said
disagreed
you-
with the state's application of it in Hardin, but it was not overruled or rejected.
Well, I think Hardin.
Hold on.
Sorry, Lemming was rejected on point because there were other factors that Lemming brought up, such as the danger of other vehicles.
It's a totality argument is what the court is stating in Hardin. It says thus, even under the circumstances in which a motorist crosses from one lane to another without necessarily raising a safety concern, that behavior can still be considered along with other facts to provide reasonable suspicion to stop for
Sure.
suspicion of driving while intoxicated.
Of course. I mean, you look at the entirety of everything to see, hey, is there enough to justify the stop, right?
I agree.
On a failure, of course, that one is just time that's insufficient, right? And I think there's enough cases to say that out there. But when you have multiple times,
Mhm.
I think at that point, that may, because they could be a potentially danger to themselves as well. Here, the only problem, my problem here is he says, what's the one word he uses?
Constantly.
Constantly.
And I understand.
Constantly is conclusory.
I understand he
is.
could have been more specific, Judge, but I mean, this is a probable cause matter. And the fact that he even put constantly rather than failure to maintain a single lane. Because I mean, I've seen it where it says traffic stop initiated for failure to maintain a single lane, you know? So he did take
I
the
mean,
time to
that's
put
so
constant.
conclusory, right?
Right.
And I mean, constantly definitely indicates more than one, right? But I don't know. What does constantly mean?
It doesn't, and like you said, it is conclusory. And unfortunately, I think that we have to go by what is stated in the probable cause statement. And in
Sure.
this case, we don't know. And if there's a question, I think it has to go on the side of the defendant.
Judge, I think we have enough for probable cause. He said constant, I mean, he still indicated.
Read it
it's
word
more
for
than-
word again, one more time, please.
Officers conducted traffic stop on defendant's motor vehicle after observing it failed to maintain a single lane while traveling westbound on TC Jester. Officer observed defendant constantly veering out of lane 1 and going into lane 2.
He also states, I'll go further because I actually went into the probable cause that was written up for the blood warrant. And in the probable cause for the blood warrant, it says almost strikes the curb.
I feel like that makes it worse, actually.
Well, I don't think so, because I don't think so,
Right.
because I think almost striking the curb is also
Because
like.
he's now swerving between 1 and 2 lanes and he's going back over and almost hitting the curb.
It is a totality, so that would be an additional
That's
fact. the
veering
officer
between
could-
lanes.
I mean, I think it's all very, very,
Judge, I'm happy to re-examine this case once we get more evidence in. I asked that you find PC today, but once we get Dash, if we can look at it, I'm happy to discuss with counsel the circumstances of the stop once we get videos. I am, but I think this is sufficient for probable cause.
I would argue that it's insufficient for probable cause, and if they do get the videos and they do feel strongly enough about the case, that they have a case that will make it past, cut the mustard, then they can refile it.
And Your Honor, respectfully, in Lemming as well, one of the facts that the officer indicated was the vehicle nearly striking a curb in addition to weaving within his own lane. So in Lemming, that was found to be enough for probable cause, even reasonable suspicion to perform the traffic stop.
It's
Well, I
also,
think there
I
was
think,
other vehicles around in Lemming, that was the problem.
Well, in Lemming, respectfully, he didn't even enter the second lane. He was merely incidentally weaving, touching the center stripe. In this case, he entered into a second lane. So in addition.
I mean, if that's the case, then if that's the case in Lemming, then there is probable cause. I mean,
Yes, Judge, and
it
that's.
says that there's,
But there's other vehicles around. in
It says
Lemming.
that he touched the center stripe of the lane, the rear tire of the vehicle, and nearly struck a curb. That was the facts that the officer had at the time when he performed the traffic stop.
and that's how it was also distinguished from Hardin, because in Hardin, it was somewhat similar in that he was kind of towing that center lane, and they held that there wasn't reasonable suspicion for a stop, which is understandable. But you also have to take into account other factors, such as this is at 2:00 in the morning. I don't know what date this was. This is on a Saturday, late Saturday night, 2:00 in the morning when bars close. There's other factors here at play, Judge. It's not at, 1:00 in the afternoon on a Tuesday.
I will state that in Lemming, I believe, correct me if I'm mistaken, but there were other cars around, and that was a factor that they brought up. near the vehicle.
All right.
It's fun.
It is fun. It is fun. It's Christmas.
I
It's
know.
Christmas.
Usually people just roll over. Nobody ever does this.
I know. My neighbors, it's my neighbor's friend, so I'm trying to help. I'm trying to help the door over here. Y'all are running.
Krista Smith?
All right, I think coupled with that one, I think that, Mr. Simon, I'm sorry, I think it is, it basically, this case here tracks that case.
I think that the distinguishing factor is no vehicles around. And I think that's what they kind of hung on to. And there's other vehicles around.
They don't even mention that here.
What?
They haven't even mentioned it here. It says here, look, it says, the combination of the tip and his own corroborating suggestions. Twice Gillo observed the Jeep nearly strike the curb, drift back and forth, and this one is within its lane, if to somewhat a lesser extent for some time. It was traveling well below the speed limit when he first observed it.
May I read a portion of the sworn statement by the officer for the search warrant?
Sure.
So the officer stated that he observed a motor vehicle driving in lane 1 and then swerve into lane 2, almost striking the curb. He continued to follow the vehicle and observed him constantly jerking while in lane 1. As the motor vehicle continued to drive, a turning lane opened and the motor vehicle veered into the turning lane and then back into lane 2. And that's when the officer initiated the traffic stop. So it seems like it's multiple
Two
lanes.
different times. So it's only 2 different times as opposed to the constantly that he wrote in his report.
Nearly striking the curb. I think it's enough for now.
Okay.
Now,
I'm not going to argue with you.
No, but
Any more than I already have.
look, I'm never going to begrudge a lawyer for doing it. That's your job.
Yes,
And I
yes,
want
yes.
you to do it, right?
Yes.
But remember, it's only probable cause.
And
It's not a beyond a reasonable doubt. If this is all that's there, but right, I don't know.
Okay.
So, all right, come on up. This is Anderson, right?
Yes, Your Honor. No criminal history.
Okay. So I want you to understand, coming up over here. I want you to understand something, Mr. Anderson, that probable cause is a pretty low standard, right? It's just to see if there's enough evidence to go forward. It by no means means that you're guilty of this offense, and that's a high standard. It's a beyond a reasonable doubt. And I can let your lawyer explain that to you, but this is just a mere hearing to see whether there's enough evidence to go forward. I think that there is. And the only restriction I'm going to place on you now is don't consume alcohol, don't use illegal drugs. As long as you can comply with these conditions, you and I will be fine. You've got a great lawyer, as junkyard dog as he can be, right? Listen to him. He'll take care of you. I'll waive your appearance. You don't have to waste your time coming to court, but just stay in touch with Mr. Simon. He'll tell you when you got to come back. Have you guys run his license? See if he has a license.
He does have a license and it is valid, Your Honor, and we've requested ALR on that, so we're all good.
Okay. So as long as you have license and you maintain liability insurance, because you have to have car insurance. If you don't have car insurance, don't drive. Do you understand?
Yes, sir.
All right. Now I'll let you guys go. So I'll have you sign a receipt with Victoria. We'll have you get with Fleischer for your bond conditions and then you guys free to go.
Thank you, Judge. Have a Merry Christmas. I won't see you before then.
Hey, thanks for watching. If you enjoyed that video, do please take a moment to like, subscribe, and leave a comment on the video. We'd really appreciate that. And if you want to keep the fun going, check out the video on the screen right now.